I'm Drew Stevenson. This is for my administrative law class. Here I'm going to be talking about the case Public Citizen Health Research Group v. Tyson. This is a 1986 case from the D.C. Circuit Court of Appeals. We're really looking at this case as part of our unit on executive or presidential controls over agencies, and we're studying it mostly because of one paragraph near the end of the case where the court addresses a claim about the role of the Office of Management and Budget, or OMB, in the proceedings that had transpired. Having said that, let's dive in. So I'm going to try to give you just enough background facts so that you know what the case is about without getting bogged down in the details here. In 1986, the DC Circuit was reviewing a rule by the Occupational Safety and Health Administration, more popularly known as OSHA, that limited workplace exposure to a chemical called ethylene oxide, abbreviated ETO. This is a hazardous chemical, but it's widely used in manufacturing and in hospital instrument sterilization. Basically, workers in manufacturing plants and hospital workers, let's say nursing staff and so on, who have to sterilize surgical instruments, were being exposed to this chemical, and there was a risk that they would suffer serious health effects. So here, OSHA's rule had set long-term exposure limits, but they didn't really set a short-term exposure limit, which is abbreviated STEL. In other words, they set some rules about ongoing exposure in the workplace, say for a typical hospital worker, but not how much exposure you could have in the short term. The court affirmed OSHA's long-term exposure limit rule, but at the same time, they rejected their decision not to issue a short-term exposure limit and remanded it back to OSHA to reconsider. Now, let's talk about the OMB's role in this case, because that's really why we're reading the case in this course. Remember that under Executive Order number 12291, at the time, OSHA was required to transmit its final rule to the Office of Management and Budget, or OMB, for review. And OMB's role was to assess the proposed regulations based on factors like cost-benefit analysis, cost-effectiveness, and benefits to society. In this particular case, OSHA was setting rules about workplace exposure to a really toxic chemical. And so they had initially created rules for long-term or ongoing exposure for someone who works in a place for many years, and short-term exposure. So they had initially done that, but the OMB had objected to the short-term limits, saying that they didn't think that there was enough scientific evidence for that. So, in order to get the OMB to approve the rule so that they could go ahead and publish it in the Federal Register and move forward, OSHA basically dropped the limit for the short-term exposure. In other words, the OMB was saying, we're unconvinced about one of the two rules you created, and the agency, instead of fighting with them about it or trying to prove their case, just said, fine, we'll drop that rule so that we can still move forward on the long-term exposure rule at least. And that's what they did. Public Citizen is basically an advocacy group for consumers and workers and so forth. And they sued and said, among many other arguments that they raised, that removing the short-term exposure limits at the OMB's behest, when he did that, the Secretary of Labor, who's technically over OSHA, had improperly surrendered his decision-making authority to the OMB. In other words, why have all these agencies if the OMB just gets to decide everything? And the removal of the short-term limit at OMB's behest, they argued, violated the enabling statute, or the Occupational Safety and Health Act. The act enabled the Secretary of Labor through OSHA to promulgate regulations. And so if the OMB is basically dictating which regulations get to go through, that violated the statute. In other words, they argued that Congress had assigned the agency, not the OMB, responsibility for promulgating workplace health standards. And without the OMB's interference, the final rule would have included this other standard for short-term exposures. And there was, in fact, quite a bit of scientific support for that, in spite of what the OMB had said. Let's talk about the holding. The court here affirmed OSHA's long-term exposure limit, which is abbreviated PEL in the case, of 1 part per million, finding substantial evidence in the record to support it. But the court found that OSHA's decision not to issue a short-term exposure limit, or STEL, was not supported by the record. So the court remanded the case for further consideration of a short-term exposure limit. I pulled out a quote from the case for those of you who like to highlight in your case books. The OMB's participation in the ETO rulemaking presents difficult constitutional questions, the court said, concerning the executive's proper role in administrative proceedings and the appropriate scope of delegated power from Congress to certain executive agencies. Courts do not reach out to decide such questions. The court continued, since we have determined that OSHA's decision on the short-term exposure limits cannot withstand our statutory review, we have no occasion to reach the difficult constitutional questions presented by the OMB's participation in this episode. In other words, the court acknowledged that there was a constitutional issue here with separation of powers, but decided that they weren't going to reach it. They were going to avoid addressing it. If you look at the Tyson opinion, you'll notice that they cite EDF v. Thomas, and I have a separate video about that, and an older case, Ashwander versus the Tennessee Valley Authority. That's a 1936 case, and they actually cite Justice Brandeis's famous concurrence about constitutional avoidance. And I want to take a few minutes to talk about that because it's actually kind of important to have in the back of your mind as you approach administrative law. Ashwander versus TVA, again, is a 1936 case where the Supreme Court struck down a federal statute on grounds that it violated the Constitution. Justice Brandeis wrote a concurrence that actually became arguably the most famous part of the case. He agreed with the result, but he said that the case should have been resolved on the merits without reaching the constitutional question at all. In his Ashwander concurrence, Justice Brandeis listed 7 principles that he extracted from prior Supreme Court precedent to help avoid ruling on constitutional questions. In other words, these were situations where the court should try not to make constitutional law. Keep in mind that we want constitutional law to be stable because it's always operating in the background of every other area of law. And so he was saying, basically, if you can decide the case on other grounds, maybe you should. And for purposes of our case, when we talk about what came to be known as the avoidance canon or constitutional avoidance or judicial avoidance, it's really Justice Brandeis's 4th and 7th rules in his Ashwander concurrence that we're going to talk about. The 4th Ashwander principle from Justice Brandeis was the idea that a court should resolve questions of statutory construction first, and then proceed to constitutional issues in the case only if resolution of the statutory questions, in other words, the meaning of the relevant provisions, didn't already resolve the case. In other words, before we jump in and say, oh, there might be a constitutional issue here, first focus on what the correct interpretation of the statute is. Some people call this the last resort version of avoidance. The 7th Ashwander rule from Justice Brandeis, I'm just going to quote him here. When the validity of an act from the Congress is drawn in question, and even if a serious doubt about constitutionality is raised, it's a cardinal principle that this court will first ascertain whether a construction management of the statute is fairly possible by which the question may be avoided. And this is more representative of what we might call the modern avoidance canon. In other words, he's saying eh, not only should you try to resolve the statutory interpretation questions first, because you might not have to get to the constitutional issues if the case is resolved on the merits once you've settled what the statute means. If the statute could mean a few different things, you should pick an interpretation that allows you to avoid holding the statute unconstitutional. In other words, there's sort of an underlying presumption that Congress acts constitutionally. The Constitution vests lawmaking authority in Congress, so there should be a rebuttable presumption that laws are constitutional. And that means interpreting the law in a way that wouldn't make it violate the Constitution if that's a plausible interpretation. The most famous treatise on statutory interpretation and construction is Sutherland. The courts, including the U.S. Supreme Court, cite it all the time. And the rule of constitutional avoidance that Justice Brandeis was setting forth is explained this way in Sutherland's statutory construction treatise. Quote, courts presume legislation is constitutional and resolve any doubt about the validity of a statute or amendment in favor of sustaining the legislation. And an important corollary of this presumption directs courts to avoid the question about an act's constitutionality in the first place, if that's possible. It continues, the fact that one among alternative constructions involves serious constitutional difficulties is a reason to reject that interpretation in favor of a reasonable constitutional alternative if available. Just to kind of paraphrase, if you have a statute that could plausibly mean a few different things, and some of those would be constitutionally fine, and some of them would, if that's what it means, it's really unconstitutional. Well, you should just assume it doesn't mean those things, right? That would be kind of crazy. You should pick the interpretations that we already know will be constitutional. Sutherland's treatise continues, courts even have found that a strained construction is desirable if it is the only construction that will save an act's constitutionality. And there are examples of this from the United States Supreme Court. What's been going on lately with the U.S. Supreme Court and the avoidance canon? Well, in 2019, there was a case, United States v. Davis, where Justice Roberts discusses it. So let's see what Justice Roberts has to say. He says, there are at least two different canons of construction that sometimes go by the name constitutional avoidance. The one the government invokes here in this case is perhaps better termed the presumption of constitutionality. And of long lineage, it holds that courts should, if possible, interpret ambiguous statutes to avoid rendering them unconstitutional. And then he continues, it is distinct from the more modern and more debated constitutional doubt canon, which suggests that courts should construe ambiguous statutes to avoid the need even to address serious questions about their constitutionality. So that's our case. Thank you for watching.